In today's topic, we will be covering Lesson 2.3, Capacity to Contract, found in our business law textbook. The goals are to determine if someone has the capacity to contract and to identify when apparent assent to a contract is not genuine. Once an agreement is formed and supported by consideration, the basics of an enforceable contract have been created. Of the 6 essential elements of a contract, the requirements of having capacity, genuineness of assent, a legal purpose, and the proper form are important only from the standpoint that they may prove this basic agreement unenforceable. When one or more of these 4 elements are not present, the law may allow a party to back out of an otherwise binding contract. One such instance involves individuals who lack the basic ability to properly evaluate and control their entry into contracts. In other words, they lack what the law refers to as contractual capacity. The law defines this as the ability to understand the consequences of a contract. This is not a demanding requirement. The law does not require the actual understanding, just the ability to understand. Also, this ability to understand does not apply to the contract itself, but to the consequences of the contract. The consequences will satisfy the law if, financial and otherwise, they are generally capable of being expressed in common sense terms. 3 instances in which the law recognizes a lack of contractual capacity are for minors, the insane, and the intoxicated. Under criminal and civil law, children under the age of 7 cannot be held responsible for a crime or a personal injury they inflict. Contract law grants a somewhat similar status for individuals who enter into contracts while under a certain specified legal age. These individuals are referred to as minors. In most states, this age is set at 18. There are 2 basic protections granted to minors and others who lack capacity. When protected parties purchase necessaries, things needed to maintain life and lifestyle, such as food, clothing, and shelter, they need pay only the fair market value, rather than the contracted price. When protected parties purchase unnecessary items, they must pay the contracted price, but retain the legal ability to avoid, disaffirm, the contract. When a party disaffirms a contract, that party indicates a refusal to be bound by it. Minors may disaffirm contracts for non-necessaries during their minority. In addition, minors will be given a reasonable period of time after they reach their contractual majority to determine which contracts they wish to disaffirm. However, the power to disaffirm is immediately cut off if the person ratifies the contract after reaching the age of majority. Ratification occurs when a person acts toward the contract as though he or she intends to be bound by it. Ratification cannot occur before the age of majority regardless of what the minor does to affirm the obligation. If the minor properly and in a timely fashion disaffirms the contract, he or she is entitled to receive all the consideration paid into the transaction. Mental incapacity is much less precisely defined than minority. The test to determine such incapacity is whether the party understands the consequences of his or her contractual acts. People with severe mental illness, severe mental retardation, or severe senility lack capacity. If a judge rules that a person is permanently insane, then the law holds that the person has a complete lack of capacity. As a consequence, all contracts executed by this person are void, whether for necessaries or non-necessaries. The court will then appoint a guardian, who is charged with the responsibility of managing the insane party's property for the good of that party. Note, however, that the insane party's obligations for the fair market value of necessaries must be paid. A person may also be held to have been temporarily insane by the court. In such a case, any contracts made by the person during the period of temporary insanity are considered to be capable of being disaffirmed or ratified as soon as the person becomes lucid, clear-headed. Intoxication can arise from using alcohol such as beer or vodka, from using drugs such as marijuana or LSD, or inhaling products such as glue or aerosols. Many courts, however, are reluctant to allow disaffirmance for temporary intoxication, when it may injure another. These courts will do so only for those who were so intoxicated that they did not know they were contracting. This stricter standard is used because intoxication is a voluntary act. If a court is called upon to determine if a party is a habitual drunkard, that is, a party who cannot turn down a drink when offered, the same rules apply as are applied to the permanently insane. Lack of genuine assent. Another instance in which individuals may be released from contractual obligations is when their apparent assent to the contract was not genuine. There are several instances in which the law has recognized such a lack of assent. Mistake. Mistakes can be unilateral, made by just one party, or mutual, made by both parties. Concealment. As a general rule, a person negotiating a contract is not under a duty to voluntarily reveal everything known about the subject matter. The resulting contract is valid regardless. Misrepresentation and fraud. A misrepresentation, an innocent misstatement of a significant fact by a party, makes the resulting contract voidable by the party deceived. If the misrepresentation is made recklessly or intentionally in order to get the other party to enter into the contract, and the other party does so without a good way to check on the untruth, the act would be considered fraud. Undue influence and duress. Mistake, concealment, misrepresentation, and fraud all deal with the quality of information provided or available to the contracting parties. Undue influence and duress deny contractual parties their ability to make reasonable choices about contracting, regardless of the quality and quantity of a party's factual knowledge. With undue influence, the dominating party to a confidential relationship pressures the dominated party into a contract that benefits the former. An example would be an attorney selling a wealthy client the attorney's yacht at double the market price, due to the carryover of the attorney's control of the client's legal matters. Such a contract is voidable by the dominated party. With duress, a wrongful threat denies a person free will to contract. Unconscionability. All of the problems with genuineness of assent discussed so far are individual ones. Courts also have had to deal with cases in which fully informed, capable individuals have, out of necessity, entered contracts that gave lopsided advantages to the other parties. To somehow grant relief from such unfair bargains, the courts had to formulate a new doctrine known as unconscionability. An unconscionable contract is one entered into as a result of the greatly unequal bargaining power of one party, who makes a take it or leave it offer to the other party who has no viable market alternative. If the resulting contract is grossly unfair to the weaker party, the offending section of the contract is void.